Judgment has been reserved in the Supreme Court of Appeal, which is determining the legality of the tribunal into misconduct charges against Western Cape Judge President John Hlophe. Constitutional Court Justices Bess, Nkabinde and Jafta applied to the SCA, arguing the tribunal is unconstitutional. The pair were scheduled to be the stat witnesses in the inquiry, looking into whether Hlophe tried to unduly influence them in a case relating to President Jacob Zuma. This is the third time the matter relating to the misconduct charges against Judge President Hlophe is at the Supreme Court of Appeal. It has been 7 years since the initial complaint. In 2013, the JSC inquiry into Hlophe's misconduct was granted to a halt. The two constitutional judges who alleged misconduct now won't testify, saying the tribunal is not constituted. Now, for the latest on the Western Cape Judge President John Hlophe's case, let's now cross to our reporter Aldrin Sampear, who heard the matter at the Supreme Court of Appeals in Bloemfontein. Aldrin, good afternoon to you. What happened during the court proceedings today?
Well, good afternoon. We heard the hearings or the arguments coming through from Bess and Nkabinde as well as Jafta, their counsel representing them there, arguing why they think that the tribunal looking into Judge John Hlophe's misconduct allegations is not constitutionally set up. The first argument relates to the formal complaint. According to the old rules of the JSC, you can go and lay a complaint and then the matter will be heard. However, due to the Amendment Act of 2013, now it says that there must be a formal complaint in the form of an affidavit or a sworn statement that says or that alleges misconduct, and only then can an inquiry be set up. This time around, we know that the complaint was laid back in 2008, so that was before the new Amendment Act came into place. But now the tribunal has been set up under the new rules of the new Amendment Act, and their argument is, considering that there's no formal complaint or sworn affidavit, they can't be part of this inquiry, which was not constitutionally set up. The other issue that they have is having the NPA prosecutor being the lead of evidence or lead evidence in the case, and that person, of course, will be cross-questioning the judges who will be the star witnesses in this case, and they are arguing that you can't have a prosecutor being involved in the removal of a judge. Per law, it must be the President as well as the National Assembly as well as the JSC. While the Supreme Court of Appeal justices said that, but it is not the JSC, it's not the tribunal itself that takes the final decision whether to remove a judge president or not. It is the JSC which makes recommendations to the National Assembly, and that status quo will remain.
Well, it looks like this matter is now moving and skating on thin ice regarding this technicality of the matter not being properly constituted. Are we going to see that committee being properly constituted so that the proceedings can get underway?
Well, when we say properly constituted, we have to ask in terms of whose definition of properly constituted, because the JSC insists that as it stands currently right now, the inquiry is properly constituted. They followed the letter when it comes to the issue of who is present at the inquiry. They even say that, for instance, they have the witnesses, this is Bess and Nkabinde as well as Jafta, would be allowed to bring their lawyers to this hearing, which means why can't we have a prosecutor as well who will be cross-examining them and who will be leading evidence. So we'll have to wait and see how far this matter goes. The other issue is that if, for instance, Bess and Nkabinde and Jafta are not successful in this case, like they weren't at the High Court, will this matter go to the Constitutional Court? And the double whammy here becomes that we already have Constitutional Court judges who are involved in this case. And remember that the complaint back in 2008 was taken by the full bench of the Constitutional Court to the JSC. So chances are, will they have to recuse themselves from the matter? And if they do recuse themselves from the matter, then who remains sitting on the bench of the Constitutional Court? Or could we see a situation where, for instance, when Judge John Hlophe challenged the Supreme Court of Appeal when it sent the matter back and said that there must be an inquiry set up, could we have a situation where the Constitutional Court judges say that, listen, we cannot hear this matter because there are too many of us involved in it?
Talking to us live from Bloemfontein, Aldrin Sampear, a reporter who is covering the matter on Chief Justice, or rather Judge President of the Western Cape High Court, on the matter at the Supreme Court of Appeal in Bloemfontein.